trial, this court found the defendant guilty of count 1, aggravated robbery, a felony of the 1st degree with a 3-year firearm specification, count 2, attempted grand theft of a motor vehicle, a felony of the 5th degree with a 3-year firearm specification, and count 3, receiving stolen property, a felony of the 4th degree with a 1-year firearm specification. And we are here today for sentencing.
Mr. Fatika.
Good morning, Your Honor. I've had an opportunity to review the PSR. We're prepared to go forward.
Go ahead.
I'd like to start out by saying that the defense concurs with the prosecutor's merger analysis as presented in the sentencing memorandum that was filed a day or two ago.
All right, hang on. Go ahead with regard to merger. How do you want to proceed on
Your Honor, the state will concede that the underlying offense in count 2, attempted grand theft of a motor vehicle, merges with the aggravated robbery in count 1. It is still the state's position that the firearm specifications do not merge.
All right, so you're going to proceed on count 1 then?
Yes, Your Honor.
All right, go ahead, Mr. Fatika.
Thank you, Your Honor. We're going to object to the imposition of both 3-year gun specifications on constitutional grounds. I think it's one course of conduct. I think it's punishing the same conduct in 2 separate ways. So we just like the record to reflect our objection. As to the PSR, Mr. Hagwood is maintaining his innocence as he has throughout. He has no prior felony convictions, 19 years old, had a couple of less serious cases in juvenile court in Cuyahoga County. He was in 12th grade when he was arrested. He was doing some work painting and fixing homes with his brother. He does have a supportive mother who is present in the courtroom. She'd like to be heard on his behalf.
All right, how do you want to go with Mr. Hagwood or his mother?
Let's start with his mother.
Okay. Would you just...
The courtroom falls silent as the defendant's mother takes the stand. Fighting back tears, she apologizes to the court and begs for leniency. She tells the judge her son made a terrible mistake, one that doesn't define who he truly is. Please, Your Honor, she says, have mercy on him. But deep down, she knows mercy may not come today.
My son has made a decision that was not honorable for himself, nor me, nor his family. I would like the courts to please have leniency on him, and if at all possible, I'm asking that, Your Honor, if you would even just consider barring him from, I'm not even sure where area I'm in, but finding some resolution. I understand that there was a decision made, and with decisions being made, there are consequences and benefits that come in behind that. I believe that King has really acknowledged and understand that his choice and his relationship with those that he has encountered himself with has brought him to a place that he should not have been. I have raised my son to be very respectable and honorable. And I know that if the shoe was on the other foot, he would not have been happy if it was his mom. So there's a lot that could be said, but again, I want to apologize to all parties that have been involved with the action that has been taking place with my son, and that you will consider some type of leniency on his behalf. Because I truly believe that he has realized that this decision can bring about a worse consequence. Thank you.
Thank you.
Your Honor, I would give Mr. Hagwood the opportunity to speak if he chooses.
Mr. Hagwood, is there anything you want to tell me before I impose sentence here today?
No, I wrote a letter, but that's all I had.
Nothing else you want to say?
No, sir.
All right, Ms. Gold.
The prosecutor steps forward with calm precision. She reminds the court of the victim, a woman still terrified to walk outside her own home. He stole her sense of safety, she says. The state pushes for the harshest sentence, arguing that every firearm charge must be served consecutively. The message is clear: choices have consequences.
Francisco, and she's never felt afraid for her safety before living in Willoughby Hills, Ohio. Before this incident, the victim and her husband would go for walks and bike rides around their apartment building, and this is something that she no longer feels comfortable doing. The defendant, in his actions and in committing this crime, stole from her her ability to feel safe and secure in and around her own home. And the defendant randomly targeted her, which represents a risk to the community at large. The defendant failed to take responsibility in his pre-sentence report, and while it is a juvenile adjudication, he does have a breaking and entering felony on his record. I would incorporate the arguments made in the state sentencing memorandum that was submitted in this case, but would emphasize that it is the state's position that all three firearm specifications must be served consecutive to each other. The act of receiving stolen property is a separate act or transaction than that of the aggravated robbery in count 1. The Ohio Supreme Court has defined the same act or transaction as a series of continuous acts bound by time, space, and purpose and directed toward a single objective, in their case, State v. Wills. Now, in this case, all of the elements of receiving stolen property were met the minute that Ford Explorer belonging to Nicholas Northup passed from Cuyahoga County into Willoughby Hills. At that point in time, the defendant was in Lake County knowingly receiving or retaining property that he knew or had reasonable cause to know was stolen, that being the Ford Explorer belonging to Nicholas Northup. And the conduct in receiving stolen property continued as that vehicle drove to the Pine Ridge Apartments as the aggravated robbery was committed, but then the conduct in the receiving stolen property continued to be committed until that vehicle exited Lake County. And while the time overlapped, the victims are different. The victim in count 3 is male victim NN, and the victim in count 1 is female victim BB. And the criminal objectives are different. The criminal objective in the aggravated robbery is to attempt to steal from victim BB a different vehicle than the vehicle that is property at issue in count 3. So the victims are different, the criminal objective is different, and the timing is different. Additionally, it is the state's position that by statute, the firearm specifications for counts 1 and count 2 must be imposed consecutively. The exception in revised code section 2929.14 B1G requires the court to impose 2 separate prison sentences for the 3-year firearm specifications. The Supreme Court has noted that this revised code section fails to provide an exception to its application when the underlying offenses have been merged, and that is from State v. Baller. And the reason for this is to acknowledge the hefty penalty of committing certain violent crimes. So because the firearm specifications in counts 1 and 2 must be consecutive by statute, and the firearm specification in count 3 should also be consecutive because it represents a separate act or transaction than the conduct in count 1, it is the state's position that each firearm specification must be served consecutively for 7 years on the firearm specifications, and the state is asking for an additional 5 consecutive years on count 1, aggravated robbery, not including the Reagan-Tokes tail, for a total of 12 years. Thank you.
Okay, I've reviewed the pre-sentence report. The victim impact statement. I've also reviewed a letter from the defendant, from Ms. Brown, and from another individual in support of Mr. Hagwood. And I have considered all the provisions in 292911, 292912, and 292913. I note Mr. Fatika's objection to the consecutive nature of the firearm specifications in counts 1 and the count 2, which the underlying offense merged with 1. I think it's clear under the statute and then by the decision of Baller that those two specs, even though 2 was merged with 1, must be consecutive, as well as the RSP in count 3. So I don't know what was, I sat here and listened to the evidence and determined that Mr. Hagwood was guilty of these offenses beyond a reasonable doubt, and it wasn't even a close call. I know that there was an argument and a remaining denial that his phone was present, but he was present, but the evidence was in my mind overwhelming that you committed.
When the judge speaks, the room feels heavier. Your mother wrote a beautiful letter, he says. You should have followed her example. Then comes the sentence minus 11 to 13 years in prison. A mother's tears fill the silence as the gavel falls. Justice has spoken, and mercy is no longer on the table.
Victim impact statement. For somebody who had not ever been involved, this meaning the victim in this case, in anything remotely approaching this, it terrified her and continues to terrify her beyond belief over a year later because of what you and Bradley did. And I don't know why you did it. I mean, your mother wrote me a very nice letter on your behalf, spoke very well of you here, and you would have been a lot further ahead to follow her example in life instead of doing what you did. I can't for the life of me understand all this nonsense that you were engaged in that had a tremendous amount of harm on the people impacted by your actions. On count 1, the felony 1, I'm going to sentence you to a definite minimum term of 4 years up to an indefinite maximum term of 6 years in prison. Whether you serve any time beyond that definite minimum is based upon the criteria and your activity in the institution as determined by the adult parole authority. They could extend it to that 6 years. That would be subject to an objection by you, and you could at some point have a hearing on that, but that's based on their criteria. On the firearm specification of count 1, I'm going to impose a mandatory 3 years. On the firearm specification that was in the count 2, the attempted grand theft, a mandatory term of 3 years. Those 2 terms, those 2 firearm specifications will be consecutive to one another by statute and pursuant to Bowler, and statutorily consecutive to and served prior to your sentence on the underlying offense of 4 to 6 years. On count 3, I'm going to sentence you to a term of, on the underlying offense of 18 months. That'll be concurrent to your sentence on count 1. The firearm specification by statute is 1 year is mandatory and will be served prior to the underlying offense. Anything more with regard to the sentencing? That aspect of it?
Your Honor, is the firearm specification in count 3 to be served consecutive to,
Yes.
or the firearm specifications in counts 1 and 2?
Yes.
Thank you.
All right. When you are released, you will be on post-release control for 5 years under the parole authority. They will place conditions on you. If you violate the conditions, the parole authority could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. If that violation is a new felony, you could get an additional consecutive prison sentence for the violation, the maximum of which is the greater of 12 months of the time left under post-release control. You have the right to appeal your conviction and sentence, the 11th District Court of Appeals. You have a right to have a lawyer appointed to represent you if you cannot afford one. You have a right to have a transcript of all the hearings that have taken place in this case. If you can't afford the lawyer or the transcripts, they'll be given to you at no cost. You have a right to have a timely notice of appeal filed in this case on your behalf. I will appoint separate appellate counsel. So, Mr. Fatika, I would ask you to file a motion to withdraw, and we'll get somebody appointed. Is there anything else, Ms. Gold?
Jail time credit, Your Honor.
115 days, correct, I assume?
Yes, Your Honor.
Okay, credit for 115 days. Anything else, Mr. Fatika?
Your Honor, just going over the math, the aggregate sentence here then is 11 to 13 years?
Correct.
Thank you. Nothing further.
All right, we're adjourned.